My name is Dr. Uzuazo Etemire. I am an associate professor of law from the University of Harcourt, Nigeria, and I'm glad to be in Nairobi for this particular program. And in this session, we'll be dealing with procedure and evidence as it relates to corporate climate litigation in Africa. And with me to have a discussion on this important theme is Mr. Mark Odaga, who is a human rights and environmental justice lawyer admitted to the Kenyan bar. He has in various capacities worked with local and indigenous communities in law and policy reform efforts, administrative challenges, and litigation to hold state and corporate actors accountable for actions that violate their right to land, a safe climate, and clean and healthy environment. You're welcome, sir. And then on my far right, we have Dr. Felix Odhiambo, who holds a PhD in law from the University of Dar es Salaam, a Master's of Law degree from the University of Nairobi, a postgraduate diploma in law from the Kenyan School of Law, a Bachelor of Laws degree from the University of Nairobi, and a Bachelor of Education degree from the Kenyatta University. I wish I had this kind of standing to accumulate all of this. He's an active legal practitioner who presently practices with the law firm JKFS Advocates LLP. Additionally, he's a lecturer of law at Kenyatta University with research interests in international environmental law and climate change law. You're welcome, Mr. Felix.
Thank you.
All right, so we're talking about procedure and evidence in corporate climate litigation, procedural issues and evidential issues in corporate climate litigation in Africa, and we can have a focal point. We can focus on Kenya as a basis for having that particular discussion, or as it deem fit, because procedural issues are fundamental. Issues of evidence are fundamental to a successful, quote, climate litigation. You know, it's one of the reasons why members of the public who are not versed with legal issues, many times I call them Facebook lawyers. You know, they can insult judges, they can talk against lawyers and say this case was so clear. How did the court reach this decision of throwing out the case? How did the case not succeed? Somebody must have taken a bribe. It doesn't happen. Whereas it's a simple case of procedures not being followed, or the procedural rules are too stringent, or maybe the right evidence was not tendered, or the rules surrounding the presentation of evidence is too stringent, and maybe sometimes unreasonable. So it's a very important issue and aspect of corporate climate litigation. I have a variety of topics under that particular head to talk about. So I'll ask a few questions and then we'll just have a discussion on this particular theme. Okay, so I'll start with Felix. When it comes to corporate climate litigation in Africa, local standard is a very important aspect of that. Right? In a lot of countries, you have no business approaching the court if your private rights have not been infringed upon or is not being threatened. It is thrown out and you'll be called a busybody. But we have always known that in Kenya, for a long time, the local standard is flexible and it allows for public interest litigation. How does that function? How has it been functioning? Is it as we read the books, anybody can go to the court and you don't need to have your private legal rights in jeopardy or being threatened or have no business with the case?
Thank you. Thank you so much, Prof. The first acknowledgement I wish to make is that under Article 22 of our Constitution, local standard should no longer be a requirement. Let me use the word should. So the Constitution removes the requirement for local standard. And considering the nature of environmental disputes, climate change, you really need not prove injury to yourself. So under Article 22, of course, that's also read together with Article 258 of the Constitution, local standard is supposed not to be a requirement. But I would say something that there is a clawback to this provision, a clawback that is not constitutionally founded, a clawback that is founded by practice. The court that has jurisdiction on matters of environment and climate change is the Environment and Land Court. Now, most of the time, this court applies. You will file a petition under Article 22 and 23 of the Constitution, and a petition filed under those articles is supposed. The rules of procedure are supposed to be what we popularly refer to as the Mutunga rules of 2013, the constitutional petition rules. So you will file under those rules, but then the courts will, most of the time, apply civil procedure rules 2010. So you have two problems when that happens. You have the problem of untidiness because you have two sets of rules of procedure. Two sets of rules of procedure being applied to the same suit, so to speak. The second data that comes with that is, under the civil procedure rules, the courts readily fall back to technicalities. So the petition then becomes very much susceptible to being struck out on grounds of technicalities. And that really has been a very big problem. I would like to, for example, mention one particular case, which is a case that I personally litigated, which is the Meru ELC petition number 1 of 2019, Mwangaza Land Property Owners Self-Help Group versus the Honorable Attorney General and others. And in this petition, the court agreed and struck out the petition on the basis that the court's position was that the petition was filed by an association which does not have a legal person. Yet Article 260 of the Constitution defines a person to include an unincorporated organization. And this position has been reiterated by none other than the highest court in the land, the Supreme Court, in a case called Mumu Matemu versus Trusted Society of Human Rights Alliance. And with that decision, the ELC essentially was even moving away from the doctrine, the obligation of the doctrine of stare decisis precedent, because it is not being bound, it's avoiding being bound by the decision of the Superior Court. And then, so you see, then now the courts are, as a matter of practice, reintroducing the requirement of local standard through the bar. And that, for me, has been the biggest challenge in terms of litigation within the space of environmental and climate change. Thank you.
Thank you very much. Maybe I didn't get it, but have the Supreme Court and the higher courts had a chance to clarify that particular practice?
What I should understand is that now that the Supreme Court has pronounced itself in the Mumu Matemu versus Trusted Society of Human Rights and 5 others. This is a 2014 case, 4 years after the promulgation of the Constitution. The lower courts, pursuant to Article 162 of the Constitution, all lower courts are supposed to be bound by that decision. And briefly, the Mumu Matemu case, what the issue here was, the Trusted Society of Human Rights Alliance was an NGO, and then it had been deregistered by the government, and then for on regulatory non-compliance. But while it was still reorganizing itself for purposes of the registration, so it filed a suit in court. And the argument by Mumu Matemu was this was an incompetent person because he didn't have legal personality. So he didn't have right, shouldn't have had right of audience. But the court's position, the Supreme Court's position was any association or any organization, whether registered or not registered, should have the right of audience. So you look at that and you can only contrast it with the decision of the ELC in ELC petition number 1 of 2019. So courts readily, I think sometimes also some of them it's out of laziness, would want a situation, something that gives them ease to strike out a matter. You file your returns that at least you concluded the matter, but then not going to the root of the question of did you deal with the substantive issues? Because constitutional petitions are supposed to be cushioned, they're supposed to be on a higher pedestal and should not be so susceptible to being struck out on the basis of technicalities. Thank you.
Thank you very much. Thank you very much. Yeah, so we move over to Mr. Mark. Across the continent of Africa, a lot of potential corporate climate litigation have failed because of evidentiary hurdles. A lot of them. What are some of those hurdles from the experience, and how can they be mitigated? How do you propose that they be mitigated?
That's a really good question. I think the first reason why that is a hurdle, first thing before we get to court, is the technical nature of some of the evidence which might be required. Yeah. And oftentimes when you're litigating, you will find that experts who are closer, or many of whom will be able to speak very persuasively on the issues that are to be litigated, might be a little bit cautious in the way. This is usually because in the context of strategic environmental litigation cases and potential corporate climate cases, the stakes are usually quite high. There are a lot of, if you talk about the fossil fuel industry as a potential category of potential corporate defendant, they use quite a lot of muscle. Oftentimes these projects are being undertaken as part of public-private partnerships, as part of government interests, a lot of contracts. And so that is the first hurdle, getting experts who might have the local context, the local knowledge, who might be willing to assist, but might not be necessarily at ease coming to court and appear as expert witnesses. So that is a substantial challenge. I think setting up a platform like this under BIICL, bringing together practitioners from different jurisdictions helps, because then there's a lot of room for cross-fertilization. So I think that is something that potential litigants might want to have their eye on, so that then it's possible, for example, and I think reference was made in the first panel to the Rapporteur fire power plant case, where quite a lot of the expert evidence was given by scientists, economists, who are not necessarily Kenyan nationals, but were still able to leverage some of the experience and expertise, perhaps even in appearing as experts in other cases, to illuminate some of these challenges. I think the other challenge once you get into court is a question of causation. And it's something that particularly, I think, if you frame your case around private law, I think the standards of evidence are a lot higher and stringent in terms of drawing the line of causation between what is the reported action or omission and the harm or injury. You will be, in those instances, I think at the mercy in Kenya of our Evidence Act, quite squarely and firmly. I think it's something that's lessened in jurisdictions that have the right to a clean and healthy environment. Because what that does, I think Mr. Odhiambo has alluded to this, is under these constitutional provisions, the strictures of needing to prove direct injury or harm are lifted. And I think I was reading even recently the Juliana case in America. It is an angle that the litigants have not tried to pursue. So the right to a clean and healthy environment, that kind of thing, at least lifts some of those evidentiary burdens from litigants. I think issues still remain where one is trying to draw a causal link, say, between certain extreme weather events to the actions or omissions of, say, corporate majors, for example. I think it's evolving in other jurisdictions. There are cases that are testing that out. Again, one potential hurdle might be even when you're capable or able to get the evidence, it's in packaging it in a way that is persuasive so that the courts can follow and also acquaint themselves with the evidence and see how it connects to the claim that is before them. I think there's room here, I think, for cross-fertilization to see how other cases, gender case, for example, have navigated these waters and claimed these cases, so that then within Kenya, there's room and opportunity for the courts to get familiar and acquaint themselves with the science, which can admittedly be quite complex.
Thank you very much. Thank you very much. In a lot of these cases, we have usually poor communities or individuals who are poor and they have a lack of access to adequate scientific evidence to back up their cases. They're usually challenging companies that are extremely wealthy and can pull any scientists from anywhere in the world, but to craft a science-based evidence that will be deployed in their favor. So what do you think is the just solution to this? Because in some jurisdictions, scholars are proposing that the burden of proof in some of these climate cases should be reversed, such that if the claimant is able to show her, a reasonable evidence, then the burden of proof should fall on the company to show that its actions did not result in that particular harm that it's been accused of, since they had the capacity to do that. Do you think that's a just solution in that particular case?
I think that is definitely something worth considering. I think I've come across this in the context of administrative law challenges. The name of the case escapes me, but it's an Indian case before the National Green Tribunal. I think in that case, the court noted that it would be unfair in those types of cases to put the burden, especially in those specialized courts like our Environmental Land Court or our National Environment Tribunal, whose purpose is to try and expand access to justice, to shift that burden firmly on communities. So in that case, the court was of the view that it is not for the petitioners or the appellants in that case to discharge that high threshold. Rather, where there are certain requirements that require a sort of adequate assessment of impacts. In other cases, in South Africa, the government case, for example, the controversy involved around adequacy of the climate change impact assessment and whether the company, in discharging that burden as part of its obligation to get an environmental license, had done that adequately. It would be unfair to place the burden of presenting scientific evidence on those local and indigenous communities. So I think I would agree with you, and that is I think, a progressive way to deal with that challenge.
Thank you very much. Yeah, so I go over to Felix. Still on this issue of vulnerable people and poor in society in Africa, access to justice remains a serious problem. And even though we have public interest litigation spreading wide across the continent, it solves some of the problems, but not all of them. Sometimes even the simple issue of transportation to court is a problem for them to give the outside of the story. In this context, what is the status of, does it exist at all, epistolary jurisdiction in Kenya? How is it functioning, if it exists in your jurisprudence?
Thank you so much, Prof. I will mention that way back around nearly 15 years ago, we had a problem of some invasive weed species in some place called some parts of Kenya, within the Rift Valley, especially it's called Baringo. There's an invasive species that was introduced there called malenge weed. And the malaria weed invaded the people who occupied that area largely pastoralists. So the malaria weed is a tree that has a lot of thorns, and then it invaded the area so much so fast and so much so that the animals weren't able to get food. Now, goats that are able to eat twigs, when they ate the weed, they lost teeth. They lost teeth, and so one time the residents filed a constitutional petition before Nairobi High Court. First of all, they had to transport themselves from Baringo, which is could be about 200 or 220 kilometers from Nairobi. And they brought with them as the evidence the destruction that the weed was causing. They carried with them goats to demonstrate to court how their goats are unable to eat because their goats lost teeth. But that is just part of the challenge. So yes, now in terms of epistolary jurisdiction, the center of it, epistolary jurisdiction deals with improving access to justice. Because it's about lessening the burden of the strict legal documentation, so that even by a letter, power of a letter, the court should be able to be moved. Because courts being the technical institutions they are, ordinarily they want to be moved by documents that they can recognize. Now, in terms of epistolary jurisdiction within the Kenyan legal space, the closest we have come to that is in terms of Article 22, Sub-Article 3 of the Constitution, 22(3)(b) of the Constitution, which provides a constitutional basis for epistolary jurisdiction. And quite importantly, it requires courts that courts should be moved even by informal documentation. And that is quite important. This particular provision has also been provided for under Rule 24, or what we call the Junda rules. So they make a provision for informal documentation, even in terms of a letter, and then they place the burden on the court to translate that informal documentation into a document that can be readily be appreciated and that can move forward. But as far as I know, in my practice in life, the provisions remain largely inoperational. All the time, the courts will be only ready to be moved by documents that, the technical documents that they can align or they can identify with. So that even though the Constitution already provides for epistolary jurisdiction, the same has not been operationalized. And I think it's likely because courts still remain very conservative. And so with that conservative background, so it then places a burden on the litigant or prospective litigant to always ensure that even if they want to represent themselves, then they will still have to get an advocate or somebody who is versed in the legal drafting process to prepare their documentation. So still, again, yes, it's there on paper, it's there in law, but it has not been operationalized, at least as far as I know.
Thank you very much. As a follow-up question, I'm thinking also about the affordability of access to courts in Kenya and across Africa. It seems to be expensive almost everywhere, including in Nigeria as well, where the government has been encouraged by several legislation to ensure that access to courts is made as cheap as possible, especially in context of levels of poverty in society and Africa in general. And even as legal practitioners in Nigeria, as part of the legal practitioner's role in Nigeria, before you become a senior advocate of Nigeria, equivalent to to a Queen's Counsel in the UK or in England, you have to have done a certain number of pro bono cases. So that just associational efforts to encourage people to render free legal services to indigent members of the society. I think the broader Legal Aid Act in Nigeria mainly focuses on criminal actions and issues like that, but not on like environmental claims by communities. What's the situation in Kenya when it comes to the availability of legal aids for corporate climate litigation, especially when the community or the individual is indigent here? I think the both of you can respond to this.
Thank you, Prof. The position is under Article 22 of the Constitution. The Constitution requires, because most of these kinds of litigation matters would ordinarily arise under public interest litigation. So the Constitution requires that enforcement of fundamental rights, the Bill of Rights, is supposed, if there is to be any payment to be made to court, it has to be reasonable. It doesn't have to be something prohibitive. So yes, the Constitution makes that preparation. And of course, if you look also under the civil procedure rules, there's a provision for, what is it called? You can apply to be considered to, you are unable to pay court fees, so that then you are able to approach a court and then don't have to pay for court costs. But those are usually very fringe. And of course, you also have provisions for, pro bono cases. The Law Society of Kenya encourages its members to undertake pro bono cases. But I think the biggest hurdle to access to climate change litigation, as well as environmental cases, to a great extent for me is the costs, the danger of costs. Like I mentioned earlier in my presentation, courts, the environment and land courts, really want to apply, most of them, not all the time, but most of the time, they really want to apply civil procedure rules to the constitutional petitions filed under Article 22 and 23 of the Constitution. Now, with that, the challenge the danger that lacks is that if you lose, then there's chance that you're going to be slapped with the costs. And that then becomes a very discouraging factor for most people. I once litigated a case, this is Nairobi Yields petition number 30 of 2019, Professor Erastus Mutiga, and another versus Nairobi City County Government and others. Now, this is, I say this with tremendous respect to the court, but this is one of the cases that demonstrates how not to conduct a case, in two reasons. First of all, we had wanted to injunct, it was about development of a petrol station within a residential neighborhood. So one of the orders we sought in our application was to injunct that development. The judicial officer declined to grant the orders in question. And her argument was that even if at the end of the day, if it turns out that the development ought not to have been done in the first place, then the court has the power to declare that the petrol station be demolished. One of the issues that my clients were raising was the issue of pollution. Fine, the petrol station can be demolished, but if the pollution is not addressed at this initial stage, under the precautionary principle, then it does not matter that there cannot be restoration, because once petrol pollutes the environment, the pollution is done. So that was the basis upon which the court declined to grant the injunction. We went ahead, the matter went to full hearing. Now, one of the main respondents in Nairobi City County government did not file anything apart from they filed, the advocate filed a notice of appointment, and then they stopped there. The court, in not appreciating what the issues were, went ahead and dismissed the petition and slapped my clients with costs, including, so costs were awarded to all the respondents, including the Nairobi City County government, that did not file anything. You know. So really, for me, the issue of cost is, so it then discourages people who would be interested in, filing PIL cases or, these kinds of suits, because there is always the fear that I could be slapped because in the event I lose. You then have a situation where the citizen will then begin to take a backseat.
Yes.
So there's no activity. A great many times. Thank you.
Thank you very much. I think that's a very interesting perspective, the issue of cost, because most times when I think about cost, I think about whether the successful claimant will be awarded cost at the end of the day, which is a challenge in some jurisdictions. Even the cost generally in common law countries follows the event, and it's based on the discretion of the judge. A lot of times, for example, experience in Nigeria shows that they either don't award any costs to a successful claimant, or they award very legal costs that even unable to cover their transportation to and fro court, not to talk about what they have paid as court fees or to their lawyer. So that's also a discouraging factor for potential litigants. What's the situation like in Kenya when it comes to the award of costs? Because sometimes in Nigeria, I sit over court to hear cases, and I hear ridiculous, so I can just pull out from his back pocket and throw at the other person and say, go. That doesn't, it has no effect in discouraging people from carrying out harmful practices as part of what they will suffer in the process of litigation. What's the cost like in courts in Kenya? Are they sizable? Are they usually reasonable? Or they are not?
Thank you. I think I need to maybe mention two provisions of the law that guide the award of costs. For constitutional petitions that through which most of these kinds of litigation may come, Rule 26 of the Mutunga rules provide that the award of costs is at the discretion of the court. And the practice, especially within mainstream high court, where most of PIL, public interest litigation, occurs, the practice has been that each party bears their costs. Okay, and then you also go to, but when you go to the civil procedure rules, section 27 of the civil procedure rules, again also it gives courts the discretion to award costs. But in terms of practice, the practice has been that for civil procedure matters filed under civil procedure, courts have interpreted that most of the time that costs follow the course, so that the winning party will be awarded costs. And which takes me back to the problem I mentioned, that when the ELC courts apply the civil procedure rules, then there is always the threat that the losing party ends up bearing costs, even though it was a PIL suit. But yes, costs can be prohibitive sometimes, especially in a matter like in this matter, because now we are in the Court of Appeal, the one I spoke about, the ELC petition number 30 of 2019. We had about 7 respondents. So depending on how many parties on the other side, because each one of them is going to serve with their bills, of course. So again, that can be very prohibitive on litigants. So yes, it depends on how many parties are involved, and of course, ultimately, how long did the mitigation, exercise last, amongst so many other considerations, but it can be prohibitive. Thank you.
Thank you very much. Yeah. I remember that I said you could respond to issues of affordability of access to courts and legal aid. Do you have anything to add to that?
Maybe I think part of what has also helped, I think, is and probably it's one of the good things to come out of COVID is the fact that it is now possible to conduct some litigation, a considerable amount of litigation virtually. It's an important aspect. At least it takes away the cost of accessing court physically. Again, with some of these marginalized communities, they might not necessarily have access to the internet. So that is something, but at least it's gone some way in helping. I think the other point I would make in terms of alleviating some of the cost hurdles is, again, as a matter of strategy and tactic, is to encourage legal practitioners, communities that are thinking of filing claims, to also broaden the avenues for solidarity. I think there are quite a number of organizations that will provide some funding to help. And so I think that also goes some way, because sometimes it's necessary. Some lawyers are willing to undertake public interest litigation cases. Some of these cases drag on for quite some time. And so the availability of that funding and the intervention of public interest litigation organizations is also quite helpful. I think I'm not aware that, at least for strategic environmental cases, we do have a Legal Aid Act, but I'm not aware that it has been particularly helpful or useful in lifting some of this cost burden. I think those are the points I would make.
All right, thank you very much. I'll just take you back to evidence that you were discussing initially. Are there any, is there any uniqueness to managing evidence emanating from local and indigenous communities in corporate climate litigation cases?
I think I'd answer that question so I'll break it into two categories. One, I think we've touched on, is to the extent that you require scientific evidence, there is the hurdle of first accessing that evidence. I'll give a good example. I think quite a number of practitioners might have filed claims before the National Environment Tribunal challenging the adequacy of an impact assessment report. There have been cases where I think, with the benefit of interacting with other scientists and other practitioners in other jurisdictions, one comes to learn that there's room to sometimes expand the scope of what one might be aware of. So an example I've seen, which I think is particularly helpful, is requiring, say, for example, a corporate fossil fuel company to account not just for the direct emissions, but also scope 3 emissions. So it's something that, again, I'll keep coming back to this, because that's something that, again, speaks to the need for this kind of solidarity platforms like BIICL, where there is cross-fertilization of ideas, so that one begins to see and test and push that hurdle, so that then for fossil fuel companies, for example, operating on the continent, is there a requirement, or could there be a requirement for them not to just disclose or account for the immediate and direct impacts, but scope 3 and end-use emissions? That is a question of sort of knowledge, depending on exposure and the levels of say, climate mitigation in a jurisdiction. But I think as the chain picks momentum, that will increase. The other side of the coin, I think, is, and I was going to say this, climate justice framing. Oftentimes, marginalized and local communities are coming up against really powerful forces. If you read some of the reports around the threats and reprisals that these communities face, it's a worrying trend. It's going upwards. And so that is something to be very cognizant about, because what can tend to happen sometimes is the threat of harm and physical harm, and that can often be a huge hindrance. It is powerful to have direct community evidence. People can speak to their lived experiences and how a potential corporate defendant's actions or omissions directly affect them. It can be hugely persuasive, but at the same time, we have seen cases that have been left hanging because the petitioners have pulled out, right? And I think that happened in the Umondi court basin case. The court intervened there, I think, to argue that since this is an action brought in the public interest, it does not defeat the claim, but it's something to be aware of, so that then considerations are taken in terms of security. In jurisdictions, I think, where you have permissive obligation of standing, it might be perhaps another reason why you might want to have petitioners or applicants who are institutional as well, so that they're pushing at least. If you have, especially NGOs, they might not be as sensitive to some of those pressures. I think the other component I'll bring in here is in terms of a jurisdiction like Kenya, where we have very permissive constitutional provisions, is allowing and being willing to expand some of the reliefs that one is asking for. So in a recent decision, I think passed in South Africa, in cancelling a license that Shell was granted for oil exploration, one of the rights that was recognized by the court is the spiritual and cultural connection that local communities have to the ocean. Again, it is not something that one might immediately think about. And so I think just having that openness and willingness to explore the breadth of remedies that are opened up through human rights and constitutional arguments is worth considering. One tool that I think is worth highlighting in the context of Kenya, where we have at least 2 indigenous communities that I'm aware of who have this, is something called biocultural community protocols. And what these are, they sort of document the important cultural values in these communities, things that might not immediately occur to someone are of importance, but of huge significance to them. And presenting those as part of evidence to the court, and even in thinking through and framing these litigation cases, the breadth and possibility in terms of the remedies one can ask.
Thank you very much. Thank you very much. That's a very elaborate response to that question. I have a question about limitation periods. Limitation periods, especially top cases. Are rigid limitation periods in Commonwealth African countries limiting potential climate change mitigation on the continent? For example, in Nigeria, when it comes to the law of torts, you bring your case on that tort. I think you need to bring it within 3 years of the act or omission you're complaining of happening. In other words, within 3 years of the course of action, when the course of action emanated. And that has been described by the court to me. Within 3 years after the cessation of that act or omission you were complaining about. But the nature of environmental and climate issues is such that the impact of that activity may not appear until many years after. And then you realize that, oh, that was the reason. By which time, if you approach the court, you say, no, it's starting bad. Or the limitation time has passed, 3 years has passed. This affects a lot of Commonwealth African countries, but the legal system that influenced or established that rule on the continent, a lot of these countries have since moved forward, by providing for other rules that okay, it can be within 3 years of when the IGAD party became aware of the environmental problem and impact on itself. So we even go as far as saying when within 3 years of when he ought or should have known that that injury was caused by the activities of this or this company. But we still have these archaic laws scattered around the continent, including in Nigeria. Do you think such laws are limiting potential climate change mitigation on the continent, and what are some of the proposals we can put up as a solution? Because we recognize the fact that limitation laws have their usefulness. I mean, you can't allow someone to sleep on their rights and wake up a decade after and say, okay, now I'm ready to challenge this company. At the time where the evidence is no longer fresh, parties have since moved on, and all of that. So how do we have the limitation laws with us but then balance them against, rather reposition them in a way that they are not a hindrance to potential corporate climate mitigation on the continent. Anyone can respond?
Thank you, Professor. Depending on how you coach your pleadings, if you want to bring it within the scope of total, as a total tortious liability, then the limitation period will certainly apply. I think for me, where I find that dicey situation, I often opt to, you know,
yeah, maybe just 2 minutes because I think this moment is not recording.
Yeah.
Not hearing.
You just
I think it's one I had. The second one.
Look, I think that you can go on because the recording is going.
Yes. So essentially, sorry.
okay. So I think the recording is going on here. We just have the technical problem here of the result. So please go on with responding to the question on rigid limitation periods.
Yeah. So if you coach your pleadings to be in the nature of, for example, tortious liability, then the limitation of actions period will certainly catch up with you. For me, my approach has always been that where that kind of situation arises and I'm instructed, then I would try to look for constitutional violation within that, because then that gives my client the flexibility of no time lapse. I keep to that because one of my former teachers at the School of Law, it's called Elisha Lawyer, told us that you must not necessarily use your client's case to develop jurisprudence. So I wouldn't want to use my test with jurisprudence, how we can avoid limitation of actions of tort law outside the 3-year limitation period. So I play safe, I think.
And just to briefly add on the issue of limitation of actions, I think one of the avenues for redress which the Kenya report highlights is also the possibility of bringing claims before an environmental tribunal. Now there you're not dealing with the limitation of actions, but I think another thing to be mindful of is if you're going that route, is that if you're challenging a license, there's often a very strict 60-day timeline within which you have to file. Now, it raises a question, because if you are not directly involved in the process leading up to the preparation of that impact assessment, you might not necessarily be aware of when the license has been issued and when time starts running. So I think in environmental justice cases, the right of access to environmental information is fundamental. And so I think one potential area to push for in Kenya is for the proactive disclosure of information as to when decisions are taken. Because only then can someone who has a mind or is interested in that potential nuclear power plant in Kilifi, but is based in Mombasa and wants to intervene on behalf of the public interest, will go and be able to file a claim in good time. So I think that's one thing that I wanted to flag this in terms of timelines and in relation to that particular avenue for intervention that litigants and potential litigants might want to be mindful.
Thank you very much. I'll ask one last question, burden on children, and then I'll give you a chance to give your final words before we get questions from the audience. Okay. So, my question on children, there is what I consider to be a unique provision in the Child's Right Act in Nigeria that provides the effect that when a child is born, the child can bring legal action against anyone who did anything after it is born. So, for example, if you pollute the environment when the mother is pregnant and it causes the child to have respiratory illnesses when it's born, that law provides that the child can bring legal action against whoever was responsible for that pollution or that situation, whether it is a blow to the stomach that resulted in an injury or whatever. And I saw it as covering potentially climate cases, such that if the health of the child is affected by, say, gas flaring, which scientifically has been shown to have a negative impact on the fetus and the mother, when the child is eventually born and has any problem, that law allows the child to bring legal action against the companies for compromising its well-being. I don't know if there's any such thing in, under Kenyan law, but my major question is, what are the opportunities for children to bring legal action, corporate legal action in Kenya when they become of age, so to say? It could be in light of anything, in light of limitation laws. I know that some limitation laws provide that if the person is a child, the time does not begin to count until the person becomes of age. But what are the avenues or what are the opportunities for children to approach the courts when it comes to claims against corporations that are emitting dangerous greenhouse gases, engaging in climate unfriendly activities? I know this is a very difficult question, but if you don't have an idea about it, just we'll take it from here.
No, first, I think that's a very really powerful vision. In the context of Nigerian law, I'd be interested to hear more about it. The one thing that comes to my mind, I think, is Article 22, because in terms of the broad categories of standing that are provided for, is someone can bring a claim on behalf of someone who is unable to. So minors, of course, do not have the capacity to bring claims, but it might be possible for individuals, groups, associations to bring claims on behalf of minors. And again, I think one of the great things we have in Kenya is right from the preamble of our constitution, there's a recognition of intergenerational equity as a key constitutional principle. It is something that is echoed again in our Environmental Management and Coordination Act. So I think there's some fertile ground to push along those lines. I think that's the one.
Your case of constitutional flavor.
Precisely. And again, I think it's casting forward in terms of, I think one of the issues that I think I've seen come up, I don't know whether it would frame it before the environment tribunal, but perhaps before the environmental court, is in terms of a cost-benefit analysis. And we're talking costs. Are we talking costs near term, or are we also casting ahead? So that the question is, if something is going to, say, contravene or impede the efforts of Kenya to meet its nationally determined contributions, and it has a long-term implication in terms of exacerbating impact for future generations, that might be one way to counter arguments against starting from that human rights perspective.
Thank you very much. Thank you.
Yes, thank you. Just a small addition to what Mark has said. Apart from,
small addition and then your final thoughts.
Oh, okay. Apart from Article 22, I would also look at Article 53. And Article 53 of the Constitution More importantly, Article 53 talks about the best interest of the child. And then Article 53, 1D, requires that children be protected from all forms of violence, inhuman treatment, and all that. And then link this up with the international environmental law principle of intergenerational unity. So that, for me, would be the way to the approach to give it. Now that there's no particular provision that is equivalent to the Nigerian provision. So for me, those would be the angles from where I would approach it, so that I would give or try to make a provision for arguing for the rights of children. In terms of my final thoughts, I think I would say that the Constitution has given us a very liberal approach to the rights to protection of the environment, clean and healthy environment, as well as which is now the enabling provision for climate change mitigation. So we've come a long way, and quite importantly also the Constitution, for example, institutionally, the Constitution creates the environment and plant code, which is supposed to be, which is a specialist code that is supposed to handle matters touching on and relating to the environment, climate change, and the like. Perhaps what I think should be one area where probably institutionally we may need to improve upon to improve climate change mitigation, corporate climate change mitigation, is probably build the capacity of this court and probably other courts as well. Build capacity in terms of address the question of who are the judicial officers who are recruited, what is their background. These courts are specialized, but the magistrate courts that support them, from where smaller matters of smaller monetary claims arise, are just general magistracy courts. So then it beats the whole logic of having a specialized superior court. But the point of origin for some of these cases is manned by magistrates without any specialized background. And similarly, even a number of judges do not have specialized training within the space of environmental and climate change law. So again, for me, human resource and technical capacity development is one area where we need to probably look at. Thank you so much.
Thank you very much. Thank you.
I think just very quickly, one of the reasons it's incredibly an honor to be into a platform like this is because of the opportunity for cross-fertilization. I think one thing that stood out for me from the keynote address is part of the challenge in conceptualizing and mitigating climate change is because it's complex and it's multi-scale and response in terms of strategizing, in terms of tactics. Potential claimants and mitigants must also factor that in. And what that looks like is, I think, broadening the scope and capacity of players who are interacting and learning from each other. It's scientists, it's NGOs, it's lawyers in private practice who are undertaking cases pro bono. It's that cross-fertilization which I think will ultimately help unlock, because we have really great collections in Kenya. I guess it's just expanding the rooms and platforms for collaboration.
Thank you very much. Thank you very much, Mark and Felix. Thank you. A lot of questions from online? Or
I asked online, I received. We can. Thank you very much for your insights. It was really interesting, and I think that what was said about the complexity of this kind of litigation is really at the core of what we are trying to study, to discuss together. So my question is about the group litigation, because we saw also before Madam President said that this is also a possibility for consumer law, and I want to understand also, based on what I could read from Omondis and the Kenyan group, there is a possibility in the civil procedural law of having this kind of group litigation. What are the hurdles for this kind of group litigation, and what are the real possibilities for making sure that this is going to be an important tool, an important procedural possibility?
Okay.
So I'll attempt a response like this. I think one of the immediate cases that comes to my mind, those in Kenya will have read about a really positive development. Fisherfolk in Lamu recently received compensation after a long-standing battle. And it was a small group of fisherfolk who brought a claim on behalf of a broader class of traditional fishermen in Lamu. One of the, I think, challenges with claims of that sort, I think, first is just managing a big group or class in terms of once you've achieved positive determination. Now, there's and oftentimes I think from a litigation perspective, in the meeting of a big group, I think thinking through what it will mean in practical terms, in terms of even collecting some of the practical information that is required, if there's meant to be compensation, for example. So I think factoring that in, because that potentially has one-time implications and cost implications. From my immediate experience, that is, I think, the reflection that I would give. I think there's, again, it's for practitioners and potential claimants to really take advantage. But at least my reading of the law is that we have very permissive rules and provisions in that respect.
Thank you.
Thank you. Just aside from what Marcus said, I think group action is very permissible. But what we're still struggling with as a society, our legal system is still struggling with, is probably the class action suits in the manner of, let's say, the US system. That is something that is still a bit very tricky in our system. I would want to give an example from a criminal law perspective. For a long time, and indeed it remains a static law, rather law in our static books, the penalty of death for a person who commits, let's say, murder, it remains lawful in our static books. We have an inmate which alleged, it's called Francis Ngoatetu case. It challenged all the way to the Supreme Court, and the Supreme Court agreed with his argument, and essentially the law, the Supreme Court talked about, agreed with him, his argument to the effect that the law is inhuman, and then now the Supreme Court sentenced him, re-sentenced him, and his co-accused, or rather his co-appellant. But then the Supreme Court, knowing so well the effect that that would have had in our criminal justice system, moved suo and indicated that their ruling or their decision in Ngoatetu was limited to those two appellants who were before it. And anyone else who is in that category would have to effectively make their own individual applications. You see, yet if class action would have been applicable, then this would have been a very appropriate case of a class action, because everyone would still just be signed on whatever case. And so you see, and then the Supreme Court also narrowed the scope of its applicability. Because they argued that this was purely for those who were convicted of murder. Yet the argument was, the issue was a legal provision that limits the discretion of court. So all sentences, from where I sit, any other offense which give courts, don't give courts the right to exercise the discretion should have suitably fallen within the Motetu case. But the Supreme Court had to give a clarification later on because now the lower courts were applying it even robbery, violence, and other offenses, which for me I thought was agreeable. But the Supreme Court said no, it only applied for murder cases. And it only applied for those two individuals. So any other person within that category will have to explore, the court system for their own cases. Thank you.
Thank you very much. Any other questions?
I would have a question. Sorry, I was not able to come right at the beginning. But I think one of the things that will be key will be the evidentiary threshold. When you invite the courts to make a finding that a corporate entity has been culpable, we do know, but we talk about in criminal cases, the standard is beyond reasonable doubt. I think in civil cases, it is on a balance of probability. And of course, when you're talking about an injunction, it will be on a balance of convenience. So now, a court sitting and adjudicating a claim against a corporate entity, what would be the possible standard? I try to think. Would it still be on a balance of probability? Would it be a lower threshold? Would it be a threshold higher than the balance of probability? I would maybe like to hear some thoughts. Thank you.
That is I think it's a very fundamental question. I think, for me, I think one way I think of approaching this is with that in mind, it might also influence how you frame your case and where you go. And what I have in mind when I speak about this is, I think if you frame your case based on private law, you're sort of constricted. I think that came out earlier in the course of our discussion. There are certain forums where I think there is more latitude. And I think one forum, for example, the Environment Tribunal, I think within MCA, the rules of evidence do not strictly apply. One of the arguments that I've seen come up in the Lamu Court case was, one is the threshold question, but the other was we, I think, talked about briefly is who carries that burden to begin with. For those administrative challenges, I think it's a question of reasonableness and sufficiency. My sense is the threshold, at least from my reading of the judgment in the Lamu Court cases, it wasn't as high as beyond reasonable doubt. It went on a balance of probabilities, so that if it's enough for potential claimant, in this case, where you're evaluating whether there has been, say, a sufficiency of evidence that shows that they have considered and adequately weighed what are the potential impacts, and that has then formed the basis for some of the mitigation measures and the administrative decision and license conditions, it will be sufficient to show that at least that on a balance of probabilities. It's definitely something that might need clarification before the courts. So yeah, those would be my reactions to that question.
Thank you, Natalie. I largely agree with Mark. Again, it depends on how did you file, how did you coach your claims. Because if you coach, for example, tortious liability, then again you have to balance of probabilities. But then I think for constitutional petitions, then you get to Article 159. Not so much during that technicalities, and then you go to Mutunga rules, largely requiring that constitutional petitions to a great extent be disposed by way of written submission, so that based on the evidence before court, so that to a great extent then you will be dealing with on a balance of probability based on the evidence you forgot. So you may really not need to go have a very high threshold or high standard. So that I think would be my view in that regard, and my experience as well.
Thank you very much. I think with that, we'll come to the end of this session. But I think just to reflect on what you have said, at least from my own jurisdiction in Nigeria, if a matter is not a criminal case, it's always a balance of probability. But I think the issue came up to court when it came to human rights cases based on constitutional provision. But people were a little bit confused because human rights cases are neither criminal nor civil in nature. They are described as sui generis. Yeah, so, but the court still held that since it's not criminal, it's a balance of probability as well. So I think, all right, so with that, we've come to the end of this particular session. We'll have lunch till 2:30. Yeah, now 2:30, and then we'll come back for the last session on remedies in corporate climate mitigation. Thank you, Felix. Thank you, Mark.